Who owns Lakshadweep? A question that has come across courts, that has come across governments multiple times. Why is there a confusion and what is the history behind it? Let's find that out. Welcome back to the latest update series of Drishti IAS. This is Divya Kawatra, and today we are going to talk about who owns Lakshadweep. All right, we'll see all about it and answer all the questions. Stay tuned till the end. So what is happening is, earlier this month, Kerala High Court settled a long-running dispute. There was a long-running dispute over the ownership of Pandaram land, that is the Union Territory, in the Union Territory of Lakshadweep. All right. The court said that the Fatima Holitage versus Union Territory of Lakshadweep held that individuals termed as Cowledars in the record who were in the possession of Pandaram land when Laccadive, Minicoy, you remember the islands coming together and then becoming Lakshadweep? Yes. At that point, when there were Cowledars, the people who have been termed as Cowledars in that Land Revenue Tenancy Regulation 1965 came into force, were the landowners under the regulation. They were the landowners under the regulation. This has been clarified. Okay. What does this mean? Who are Cowledars? We'll talk all about that. Okay. Just stay tuned till the end. This is regarding the ownership of Lakshadweep Island and different parts of it. All right. So what is the background here? Understand what are the geographical constraints. Lakshadweep, that is India's smallest UT, that is 32 kilometers square, 36 islands, 10 inhabited. This has a severe land scarcity, obviously. That's why ownership of even small parcel carries high economic value. The land is less. Yeah, that's supply demand. We understand that, right? The supply is very less, so the demand is very high, and the value also is very high, right? So because of that, it matters a lot even if it is about a small parcel of the land, okay, that carries high economic, social and developmental weight, especially with expanding infrastructure. What is Pandaram land here? Historically, Pandaram land refers to land owned or managed by government or local ruler, that is Arakkal kingdom of the older times. Whatever was managed by them, that came to be known as the Pandaram land. Okay. Over generations, the land was leased to other people, right? They were leased to the islanders under the cowl system. They had a system of leasing the land where occupants were termed Cowledars, right? Right? Cowledars, like in English, it becomes Cowledars, but it is basically in indigenous language, it is Cowledars. There was a call system, and under that there were Cowledars. Right? These Cowledars were the inhabitants there who had leased the land, who had the land on lease, the island on lease, given by the Arakkal kingdom, which was subject to conditions like you have to do land improvement, you have to cultivate coconut, all these conditions were given to them, that for this purpose you can have the land, otherwise not. These became the Cowledars and given the land by Arakkal kingdom. This is where the story began. But what is the conflict here? Once they started residing, after that kingdom obviously got diminished. So now people had the lease, people had the land, they had been cultivating over it for years. So they started taking ownership of it. Rather than the lease, they started taking ownership because they had been working on the land for so many years, right? The conflict came because the clash happened between Laccadive, Minicoy and Amindivi Island Land Revenue and Tenancy Regulation. Why so? Because when this was being divided, broadly, they defined a landowner to include any person shown in the government record holding Pandaram land as Cowledar. The Act specifically said that in the records, anybody who is being shown as Cowledar, right, holding the Pandaram land, that means the land given by the kingdom, Arakkal kingdom, will be considered landowner. Landowner, that was defined in the section 2nd of this 1965 regulation. The second thing the Act said was they provided a mechanism for conferring formal occupancy. Like this was not formal, this was older record. Now after independence, we required new formal records according to the new system. So they said that the official record, official occupancy rights were given on 3 categories, right? Pre-1965 Cowledars, other occupants, and post-1965 allotted lands. These 3 categories came forward. The pre-1965 Cowledars were already there in the record. After that, they were distributing more land to other people, and plus post-1965 allottees. These three categories were divided, and that's how the land ownership was to be given. That was 1965 regulation. Clear up till here? Yes? Okay. So then what happened? Then came a conflict. Why conflict? Because when UT administration stand was that they claimed that pre-1965 Cowledars were mere lessees, like they only had leases on the government land until they secured a formal order under Section 83. Under Section 83, if you get the formal order, formal occupancy, only then you have the land. Otherwise, you are merely somebody who has leased the land. That's all. Who had the land on lease, not the ownership. They said this. Now, island occupant stand was that they said that pre-1965 Cowledars were inherently landowners under this section. UT administration is talking about this second section, that is 83. And the people are talking about Section 2nd. They're saying that according to Section 2nd, we have the land ownership. And UT says that according to Section 83, you need to be given the ownership, otherwise you don't have it. As a Cowledar, you need to be given that. That created conflict. Do you see the point of conflict now? Two provisions, totally opposite, and now there is a conflict between them because they are conflicting. The opinions in both the sections are conflicting, and that conflict is further causing problems. Do we get that? Yes. So this is the core legal conflict. Now 2024 resumption escalation again happened. There was another development in the case when in 2024 district collector issued orders to forcibly take possession of Pandaram land across islands, that is Androth, Kalpeni, Kavaratti and Agatti. Many of these islands, from them the Pandaram island possessions were taken away. Administration classified the land itself as government property rather than Cowledars, right? Compensation was given only for the improvement made on the land. Whatever improvement you have made on the land, compensation will be given to you for that, because that's why you were hired. That's why you were given the land on lease. You were working on that. You will be given compensation for that, but not the ownership. And government will take the ownership, like tree structure, whatever you have done, and rather than paying full market compensation for the land. They said that you won't get the price of the land because land is not yours. You were only working there on lease because you wanted to do improvement works. That was the purpose for lease. That was the purpose, we read that. So now this decision further aggravated the problem, and then they had to move to court, and then conflict was happening in the court also, and now the judgments are coming. So now what High Court has to say on this? High Court accepted petitioner's argument and said decisively against the administration on 4 counts. On 4 counts, the court actually went against the administration and in favor of the people, in favor of the petitioners who said that we owned the land for years and years and years. We have been working on them. All right. So pre-1965 Cowledars are recognized as landowners. Number 1, that was the judgment. How so? Cowledars and their legal heirs are assigned. Whoever had the possession of Pandaram land prior to the commencement of 1965 will be the landowner, right? And they do not need a separate Section 83 occupancy to establish this ownership. This is what court said. You don't need that. You are directly an owner if you satisfy the need under Section 2nd. You don't need Section 83 then. Number 1 thing. This conflict has been resolved. Second is collectors takeover orders that were here. Another problem that arose. District collector has no legal authority to do that. So the entire decision has been quashed, and the June 2024 directive was merely an improvement. They were declared without authority of law and has been completely struck down. They have no leg to stand on. The district collector order has been completely struck down. The third problem that was there, this 2024 resumption. All right. Next thing they've done is amendment. 2023 amendment has been struck down as completely unconstitutional. The entire amendment. How so? 2020 amendment section 15A, they said that the transfer of Pandaram land, whenever it will be made, the transfer of Pandaram land, when it will be made to the scheduled tribe islanders on or before December 31, 2019 are valid, protecting ST occupants, and this was introduced after statutory consultation with NCST, right? So 2023 deletion is that administration abruptly deleted this section. When they came up with the amendment, they abruptly deleted this section and altogether all the rights were gone. Altogether, they did away with this entire process and they said that we are deleting it, and that became wrong without even consulting the NCST. That too, without consulting NCST, that obviously became unconstitutional, right? So court ruling is that they said that this deletion is unconstitutional due to non-consultation with the NCST, and that's why it is whatever is affecting there, they restore the process and protect the benefits of section 15A, and this is reintroduced now. The deletion has been declared unconstitutional and this has been reintroduced now. It is again working in the work, right? Another thing that has been done is mandatory timeline for formalization, right? What is another thing? The UT administrator has been directed, how so? To formally confer occupancy to pre-1965 Cowledars within the 6 months, whatever rights they have, or their heirs. If they are not alive, their heirs will get that, but you have to do it within 6 months and the rights should be given, and all other pending applications under section 83 will be settled within 8 months. Guidelines have been given that you do this on a quick basis and you resolve this as soon as possible. Within 6 months, you give them the rights and the lands, and for the pending cases, you solve them within 8 months, right? This is the High Court decision on that. What are the key takeaways here? Status of the pre-1965, this is treated as temporary tenants needing occupancy. And after the ruling, this has been recognized as full statutory landowners. In terms of land acquisition basis, earlier the status was that administration claimed ownership of land, they paid only for improvement. Now the acquisition of land will be given, the ownership of the land will be given. ST Transfer Protection Act, before ruling, they struck down by 2023 amendment without consultation with the NCST. Now they have been restored. State power limit, executive orders were used to resume the land, but now after the ruling, executive actions are completely restrained and rule of law has been upheld. This is the current scenario that has happened here. Is this clear? Do we understand the summary, like before ruling, what was the situation and what is the situation after ruling, what changes have been done and what is the current status of it, and how High Court has completely stood with the people and going completely against the administration? Yes? Exactly. Now, on that note, what is the broader impact and what are the remaining questions here? And the remaining question is that public purpose acquisition. Judgment does not prohibit government from acquiring land for infrastructure, environment protection, public projects. No, they're not saying that you can never acquire land here. You can for projects, whatever there are necessary, but on the basis of that act and the conflict, you cannot do that, right? And interplay with town planning also, Lakshadweep town and country planning and development regulations, they will have to intersect with that and they will have to consult them and govern how the land can be held here, right? Exactly. So we saw the term that is Pandaram land. I hope it is clear up till here. Yes. Do you agree with the judgment here? Yes. Does it feel good? People getting what they wanted and what they deserved? Yes. Tell me in the comment section, are you in support of the agreement or do you have some questions? So now Pandaram land, land originally belonging to the sovereign ruler, that is Pandaram land, then given on lease. Cowledar, a guarantee or a grantee or the person who is taking the land on the lease, who received Pandaram land under historical lease agreement. Okay. And then there is Janmom land. There was another category, that is Janmom land, that is private ancestral property owned fully by indigenous islanders, that is apart from Pandaram land, because there must be some land apart from Pandaram also. King or the sovereign state would not own everything. There would be some private land also. That private land at the time was called Janmom land. Like there was Pandaram land, like there were Cowledars. Similarly, there was Janmom land. Okay. These are the terms that we refer to and something that we needed to understand. I hope this is clear. Yes. All right. On that note, let me remind you that we have Raksha Bandhan offer going on. Yes, Raksha Bandhan offer. In that, please pay attention that this is a special scholarship offer only for female students for offline batches. For offline batches for female students who will get 21% scholarship over offline classroom program for GS Foundation course as well as the combo. All right. This is only for new admissions exclusively for female aspirants, valid at Drishti IAS centers because this is offline at the centers. All right. And the offer period is 25th August to 5th September. Last date is 5th September to avail this. Don't miss out on the deadline. Don't skip out on this Raksha Bandhan gift for you that Drishti IAS has brought. Right? Exactly. The last date is 5th of September. And if you have any doubts or queries regarding this, you can give us a call on 87501. Do not miss out on this beautiful gift that Drishti IAS has to offer this Raksha Bandhan to our female aspirants. Yeah? All right. If you want to join us for more such current affairs daily, you can join the session at Drishti IAS English channel, Monday to Saturday live at 8:30 a.m. What is the timing? 8:30 a.m. where we discuss the Hindu newspaper, PIB news analysis, as well as practice questions for current affairs. All right. Okay. So on that note, let's solve the question for latest update, shall we? The part that we've read recently regarding the strategic implications, whatever we have seen, we'll solve a question regarding this. Okay. All right. That's about it. Thank you so much for joining in, and we'll see you in the next session. Till then, take care. Thank you. Bye-bye.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.